Thank you, Memo. Thank you very much. Hi, everybody. Welcome to the training. We're going to go over today our contract to lease, which is obviously our offer. And again, as Memo said, you can find this information online. You can follow along with me on the PowerPoint presentation as we go. It's important to make sure that we're all using, let me enlarge this screen here. One second. It's important to remember to always use the latest contract. The contract to lease that we're going to use today was revised last year in March. So from time to time, these contracts are updated. So I want to make sure that you look at the bottom left hand of the document you're using to make sure it's the latest version that you're using. So again, the one we're going to start with is the contract to lease, which is our offer. And the latest version being 321. Let's see, can everybody hear me? Is everything good? Yeah. Okay, so we're going to start with the first part, which is the contract to lease. As I said, the purpose is twofold: to make an offer to the listing agent or the landlord and work out all the details. So, and to confirm your agent commissions. So a lot of people ask always, oh, do we really need a contract to lease? Can't we just go straight to the lease? It's really important to have the contract to lease there because, again, it sets up all the rules. And sometimes when the listing agent does the lease, it may not be exactly what you were asking for. So you always need to make sure that you use your contract to lease to start the offer. I always suggest that everybody make sure before you do the contract to lease that you go to the tax roll, use the address that's on the listing, obviously, that you're going to make the offer on, and make sure that the owners are correct. If it's an LLC, you want to make sure you have the LLC name. If it's two owners, both of those owners will have to sign off on all your contracts. And you want to make sure that that information is correct that you're using. The contract to lease that we're using can be found on Form Simplicity, as you know, if you want to use e-sign. And also it's on londonfoster.net under our office manager menu. As you're looking at the property before you make your offer, you always want to make note of the appliances that are there, what window treatments, if there are any, if it's a furnished apartment, if it's not a furnished apartment. You always want to make sure of the contents of the apartment. Sometimes you know, you may miss when you're back at your office writing the contract to lease, you may think, well, wow, I don't remember if there was a dishwasher or not. I don't remember if there was a microwave or not. So you always want to make sure while you're touring the property to make personal notes of what's in there so it can transfer to your contract to lease. As I mentioned, you want to make sure you go to the county tax site, and you can find the county tax site in the records just by looking at the listing and go into the folio number or the property ID number. And if you tap on that one time, it'll take you right to the tax roll for that particular property. And it will show you the owner's names there. So you can make sure you copy those from that tax roll. You always want to make sure when you're doing the contract to lease, particularly before you send it to the agent, you always want to make sure you have that first month's rent in escrow at our office. A lot of times people wait until they do the contract to lease to see if the agent accepts it or not, or the listing agent. But it's always a good idea because it says right on that contract to lease that it's already in escrow. You don't want to have to track your client down to get that money after it's already been approved. So you want to make sure you get that cashier's check. Memo went over how to do the escrow. So again, you go to londonfoster.net, look under My Deals, and you'll find the escrow information, how to do that deposit. As he said, Bobby has a video there and you can walk through to do the escrow. And you'll also want to request that escrow receipt as soon as possible from our, also on that same screen. And there's on the drop-down menu, there is a button a tab that you request the escrow. When the client makes the escrow, you always want to make sure that you get the receipt. They can go to Wells Fargo, which is our bank, and deposit the escrow themselves at the cashier's window. Then they'll get a receipt. have them to take a picture of that receipt, or if you do this on their behalf, you also need a copy of that receipt so you can send that to our escrow department when you're requesting the escrow letter. So make a photocopy for your records. Okay, so we went over that deposit at Wells Fargo, where to do that. Under My Deals, we request the escrow letter. And you need to send that escrow letter along with your offer. So on each contract to lease, you want to make sure, of course, that the parties have signed and initialed the bottom of every page. It's 3 pages long, so that's very simple to do. Make sure the spelling of all the names are correct. Check the address twice to make sure you have the correct address or correct apartment number on it. And make sure that if you have done any changes, if it goes back and forth from the listing agent back to you, back to the sellers, double check that all the changes have been initialed by both parties, both the landlord and the tenant, and that everybody is in agreement. Double check the agent information, double check the broker information, and also the commission. The commission can be found on the actual listing in the MLS. So you want to make sure, if it's some people for leases, they do 5%. Other agents will do a half a month because the math is just more simple. It's easier to split whatever the first month payment is into than doing the math for the 5%. But anyway, just make sure that you double check that information. I always print a copy of the listing agreement just to make sure that you have that information correct, or keep it up on your computer as you're filling out your contract to lease to make sure you have the correct information. You want to verify the dates of the lease using a calendar, obviously. And you also want to make sure that the building where you're moving, if they have furniture to move in, that date corresponds to your start date of your lease. For instance, if some buildings don't let you move in on Saturdays or Sundays or holidays, you want to make sure that your dates correspond to what the move-in instructions are for the building, and also the dates that your client and the landlord agree to. Also verify the date of the last signature. Again, I mentioned if you have any changes, all those things need to be initialed. If you are using e-sign, it'll be dated, and also the timestamp will be on there. So you always want to make sure that that's the date, that's your effective date, the last signature or the last initial. Okay, so let's see. I'm going to go over the actual contract to lease. I think it's here. Sorry, we just moved this around, so I'm going to look.
Nanette, real quick, before you move on to the next thing, I just wanted to mention this because I see a lot of the stuff that happens in the back office in regards to verifying agents. So guys, obviously, if this person has a listing up in the MLS, they're active, right? So when you're making the offer, then that's one situation. But if you're the one with the listing, always verify the agent who's sending you an offer. So remember, we can't pay out to somebody who is not active, who is inactive, or is in default, or is involuntarily inactive. So you always want to make sure, and I know it's one extra thing to do, but always look up the agent, always look up the broker. You want to make sure that you have that information, and you want to make sure that they are active in the DVPR, because we won't be able to pay them. And if that's the case, you probably want to get to know that ASAP, and not when everybody's getting paid out, and then that person, you have to tell them, oh yeah, by the way, you're an inactive and voluntarily inactive, we can't pay you. So it's just one little extra step, but make sure that you verify that.
Mm-hmm. Thanks, Memo. Okay, so we're going to go to an example of the contract to lease that you should have in front of you. So remember, this is not the lease. This is the contract to lease. This is our offer. So you, again, want to verify the parties, landlord's name from the tax roll. You need to, it's a good idea whenever you're doing the rental requirements, which I'll go over that too. We have a list of rental requirements on londonfoster.net. And you always want to make sure you get a driver's license or a passport with the legal name of the parties. So you always want to make sure that those names follow exactly for the tenant as it is on the ID. So I usually, again, get a copy of that, take a picture of their ID, make sure you get that ID so the correct spelling's on the name, it's their legal name, etc. So on here, we have the landlord, Jane Doe, we have John Doe as a tenant. If there's more than one person that's going to live there and they're over 18, all those people need to be on this as tenant. So all associations in Miami-Dade and Broward require you to have everybody over 18 on the lease because they're financially responsible. So make sure that you get IDs for either party, both parties, if there's more than one party. Okay, so we have the first part, so I'm going to go over one is Jane Doe, prospective landlord, John Doe, prospective tenant, agree to execute a lease no later than, and you write in the date there. So if you're doing an offer for today, for instance, then you would want them, give them 24 hours to respond back probably. So we would put today as being the 16th, March 16th. The lease will include terms set forth in sections 3 of this contract to lease and other agreeable terms. So there is a spot where you can write agreeable terms. Generally, overall, the landlord, the listing agent will prepare the lease. If you have the opportunity, I like to do my own leases if I have either the landlord or the tenant. But usually they, when you give this contract to lease to the listing agent, he or she will want to prepare their own lease. Section 2, the deposit. This is really important. I mentioned this a little bit ago, but with the intention of entering into a lease with a landlord, tenant has paid the amount of money for the first month's rent generally is here. So in this case, we're using $3,000 for the deposit to London Foster. And you should have by this time, you always want to collect the first month rent, put it in London Foster and have it there. Again, you don't want to go chasing down your client for that money after this is already signed, or if you don't have the money in the deposit, then this can come back if it cancels, where you've said that you have it in our London Foster account and you actually don't. So you always want to collect that, get the receipt from our escrow office and send that along with this to the listing agent. Upon execution of the lease by both parties, the deposit holder, which will be London Foster, and again in our escrow, London Foster LLC is our legal name for London Foster, is holding the deposit. The property address, always check the property address. I've used to use their office in case anybody doesn't know. This is our Miami Beach office address, 407 Lincoln Road, Suite 10G. So I just use that as an example. You want to make sure that you check if it's furnished or unfurnished. If it is furnished, I generally do an inventory page, and the inventory page you can get from the listing agent, or as you have gone through, you can ask the listing agent as you've seen it, what is included in that rent. If it's a tenant in place, you'll want to verify if that furniture belongs to the tenant or if that furniture belongs to the landlord. But anyway, you can attach the inventory if you have it to this sheet. You can always wait till you get the lease also and attach it, but it's always good information here to note so the tenant will know what they're responsible for in that apartment or what they need to bring with them when they move in. You always want to put on the next section in line 3, it will be used only for the resident and occupied only for the resident or the following person. If they have their grandmother, their father, their mother, somebody under 18, that's where you would put that information there. If it's tenant only, I like to write tenant only, and for that reason, I just don't like to have any blank spaces on my contracts to lease or my leases where other things could be written in but not agreed to. Number 4, the lease term. In this case, we're going to use April 1st, 2022, and ends on April 30th. It's a 1-year lease and ends on April 30th, 2023. So make sure those dates correspond. And again, check with your calendar for the move-in date and with the building rules to make sure that those dates correspond and it's okay for that client to take possession on that date. Number 5, this is a really important part. It's one of the most important parts of your contract to lease is the money due before occupancy. So this form on Form Simplicity auto-populates, which means you don't have to fill in the sum of $9,300. You can go on down to first month's rent, which they've paid in advance to London Foster, the $3,000 due on March 16th. You can put that. If they're giving a last month's rent, that's what the second line is for. That's not for the first, but that's if they're giving a last month. In Miami Beach right now, most of the agents are doing 2 securities. So we're no longer really using a last month for the most part, but most people would put 2 months security. So on our example, again, we're doing that. We're using the first month, which is the commission basically for the agents, which is $3,000, which is in London Foster on our first line. And then we're going to last month. There's no last month. Security deposit in this example is $6,000, which is 2 months rent, which is due at walk-in on April 1st, 2022. So the next line is security deposit for the association. Again, as you guys know, some associations are collecting a deposit for common areas. Some of the higher end properties do this. They might have, a game room. They might have other amenities that the gym, or for whatever reason, they're collecting security deposits in case of damage. So that amount would be placed here on the next line if that applies. The next thing is a pet deposit. And you want to make sure that the pet deposit is definitely filled out here. So in this case, it's $300 for the pet deposit is to be returned or not returned. If it's a non-returnable pet deposit, I usually write right beside it, non-returnable pet deposit. Some owners or landlords will request that it's a non-refundable because they charge supposedly a cleaning fee or something for the pet. So again, in that, all these monies are generally collected at move-in, which in this case is April 1st. So
Nanette, if I can interject just one little commercial here.
Yep.
Because I see this with agents all the time. And again, it's all verbiage but verbiage matters.
Mhm.
Guys, we are not to collect deposits for rentals. Deposits are only collected for sales. When London Foster puts money for a rental in
Mhm.
escrow, it is the first month's rent.
Yes.
Oh, but Memo, I want to put the first, the last, and the 17th month's rent into escrow. That is not the purpose of escrow. Escrow is to hold the first month's rent in escrow up in that safety cloud until we are ready to close. And therefore, based on the listing agreement, we can pay out commissions. It is not to hold money or bear interest or anything like that for the landlord. When it comes to rentals, the first month's rent to London Foster, last month's rent, security deposit, any additional deposits must be made out to the landlord. Like Nanette said, if there is a third party, which would be probably a property manager, that must be made out directly to the property manager. Guys, protect yourselves. Don't make it out to the landlord, because guess what? The landlord's not going to cut that check for that property manager. And now you're in a pickle. So always make sure that your clients write out those money orders or checks or deposits or whatever you want to call it correctly. Again, first month to London Foster, last month in security to the landlord. Any additional security must go directly to the management company. Always require that they give you a personal check, a money order, a cashier's check. You are never to touch, accept, even look at cash. So just be very, very careful. There's a lot of fraud going on, and you do not want to be a part of it.
Thanks, Memo. Yeah, in addition to that, just another side note, the listing agent should be able to give you 2 things: the contact phone number to the association to find out if there's any common area fees. You don't want to find out after you've signed this that there's some common area fee. So you want to make sure that you get the contact for the property management association, or maybe in some smaller buildings, the board, the contact for the building. So you want to get that. You want to find out what the application fee is, how much it is, and you want to make sure that if there is a common area, who those money orders or cashier's checks are made out to. Memo mentioned personal check for my clients. and this is just a personal thing with me, I only accept cashier's checks or money orders. And everybody's probably familiar with Publix around here, but I usually tell the clients to go to Publix, or to, if they don't have a local bank, go to Publix and get money orders. You can get them in increments of $500. So for instance, so always, and have them to keep the half of the receipt actually from the money order and write the rest out. So if it's a money order that's going for first month's rent, on the money order, it's written to London Foster for the first month. Anything else they would need to do is written directly to the owner, landlord, or to the property manager. And he said, who to give money to, who not to give to. It's 100%. You're never, ever allowed to write money directly to another agent or to their broker. So unless their broker is also a property manager, and that's verified by the maybe an email or a letter from the owner, you never want to make out a check or money order or give any money to the other agent. At walkthrough, if you're doing a walkthrough, if the agent is collecting for the owner, make sure that all those funds, those checks, money orders, cashier's checks, are written to the owner, even if you're handing it to the agent on the day of the walkthrough. So verify who you're giving that money to and make sure it's going to the correct party. Okay, going on to paragraph 2. A lot of times people make a mistake here, and they fill in all the amounts that they've put on at the top of the section above it. Paragraph 2, if you move up to paragraph 2, paragraph 2 is only the money that's in the first month or going to the deposit. So that's all you carry down here. So the paragraph 2 deposit, so refer back to paragraph 2. In this example, I collected $3,000, which is the first month's rent, and that's where it goes, and that's what it's for. If you collect up front for that deposit, again on number 2, section 2, then you would put it over here under security deposit or any other fee here that you might collect. But anyway, you want to put the first month's rent here and refer back to, it should be the same amount that is in paragraph 2, not in paragraph 5. So I just wanted to clear that up. Okay. Again, it says here, if left blank, it will be credited to the first month's rent. I suggest not leaving it blank. Both parties, all parties need to know what that's for. So again, I would write it in there. I prefer to write it in there. So there's no confusion to the agents or to the tenants or the landlord what that money was for. Number 6, moving on, rent payments. This is added here because some of the short terms have taxes on them. So you want to make sure of that with the listing agent. This is a regular condo rental that my example is made from. So the total rent for the lease term is going to be $36,000. It's 3 times 12. Pretty easy math, $36,000 excluding taxes. And again, if you're renting from a short term or some of other hotel type situations, they may apply tax, and the listing agent will be able to tell you what that tax is there. So that's where you would include the tax. In my example, we don't have tax on it, so I always write on there 0. Again, I don't like to leave any blank spaces on my documents. With my lease and my proposal, they're going to pay on the first of the month in the amount of $3,000. So that's there. Again, anytime it says blank, I don't like to leave it blank. I fill it in so everybody's on the same page. Number 7, if they have pets, in my example, we've paid a $300 pet fee. So pets are permitted. And in this association, you always want to check too. Pets on at least on Miami Beach where I work, they are common. So you want to check if the building has any restriction or rules for the pounds of the pets, large pet, small pet, how many pets, 1 pet, 2 pet, and that's what it's here. And generally, back to the pet deposit, if there's more than 1 pet, they can actually charge for 2 pets at pet deposit for each pet. Obviously, everybody probably knows this by now. If you have a service animal, you cannot charge any fees or any deposits for a legal service animal. So again, in my neighborhood and on the beach, they're doing emotional support pets. A lot of buildings are no longer allowing those, but it varies property to property. And just again, don't check with the listing agent about that so much as you check with the building manager or property manager, because they ultimately will rule this. If there is a furnished apartment and the owner does not permit pets because they don't want their furniture, their apartment, having a pet in it, they can also restrict personally that they don't allow pets. They cannot restrict if it's a service animal. So the key word here is service animal. This apartment prohibits smoking, so you want to fill that out. And again, this is a 3-page document. You want the tenant, if there's more than one tenant, you put in each tenant would initial the bottom of the page. Of course, the landlord would be initialing there too, whether 1 or 2 people. Again, more than one party to the contract to lease or lease, you have to make sure everybody agrees and everybody initials. The utilities. And most of the condos in Miami Beach, water, sewer, and trash, it's pretty common for those things to be included. If it has a washer and dryer, sometimes they don't include the water and they're individually metered. So you'll want to check this. So make sure that you read this part, because it says except for, that the tenant is responsible except for water, sewer, and trash removal. Write those things in. Some of the things that you want to check on is if they do pest control. Most of the buildings may include pest control, but maybe they don't. So always check to make sure. And again, it's best to verify the information on the listing agreement with the property manager. What is included? What does the tenant pay? We don't want any surprises for our tenant after this document is signed. So make sure that you double check this information. And sometimes our MLS is not correct. So again, get the contact. And I can't stress this enough, because sometimes the information doesn't make it to the listing that's truly what the building allows or doesn't allow. So always verify this information with the building manager or the property manager. Maintenance, landlord is responsible for maintenance of everything. And this says except right here. So make sure except, which means what's the tenant responsible for? Okay, in many instances, I tend to put the same thing, light bulbs, that they're responsible if a bulb blows out, they're going to put a light bulb. When you do your walkthrough, there should be all the lights working and all the bulbs should be there. But over time, if they're there for a year, or if a bulb blows, it's usually the tenant responsibility to change a light bulb and pay for that. AC filters, if they have AC filters, it's usually the tenant responsibility, either once a month or every 3 months, whatever the owner wants you to do to change those AC filters. They can easily buy those either Publix, Walmart, Ace Hardware, anywhere they can pick up an AC filter. And also the smoke detector batteries. On my listings, I generally change the smoke detectors every time I get a tenant there. If it's an annual, I do it annually for the owner, have the owners to check those batteries. There's usually a 9-volt battery in there. So you just want to make sure that that's working. And if it happens to go out again, just like the light bulbs, the tenant can get the 9-volt battery and put that in, and that's what they should do. These things might vary apartment to apartment, but for the most part, these are the typical things I put there. You need to check again with the association, which we've already gone over that. The tenant will pay a non-refundable application fee. Make sure the tenants know if they do not get approved, that money does not come back from them. That money is used by the association to do their background search, their criminal background if they do that, and to do their services to approve the tenants. So that is a non-refundable. And we put here by March 15th, 2022. So usually it takes 2 weeks for an average apartment complex or condo. Sometimes they can take legally up to 30 days to approve a tenant. You want to caution people that are in a hurry to move. It may not happen that fast, even though you have the contract to lease signed. And even though you have the lease signed, it's up to the association to get that approval. And on no circumstances should you ever try to move a tenant in without that official letter or email that says that they're approved. The owner can get into trouble, the tenant can get into trouble. So you want to make sure that you always have that approval. Okay, let's see. Moving on to number 12, additional terms. This is an area if there's any additional terms here, and this should be done, it says by an attorney. If you want to make any amendments to the lease form, it needs to be done by an attorney. We don't really have addendums to leases, but if you do have like the contents, I consider that an addendum to the lease with the contents if it's furnished. So just be careful about this because the state of Florida doesn't allow us to make any amendments or omit. A couple of weeks back, we had somebody on the Telegram that said, can they strike a bunch of sentences from our leases and from our contracts? The answer is no, you can't really strike that stuff. Legally, only a lawyer can strike information because it's a state of Florida lease. If all
Nanette, please say that again. Please say
Yes.
that again. Please say that again.
Yeah, you cannot strike things as an agent from the leases or from our contracts legally, and you can contact our Florida hotline about this. Only an attorney can make amendments, strikes, and remove or replace things from contracts. With that said, we see this all the time and it can get you into trouble. So you always just kind of want to stay away from this if at all possible. If all parties agree to it, people do it, and I see people do it, but would it stand up in court? I always ask myself, would it stand up in court? Did I do this? Did the landlord do it? Did the tenant do this? So you always have to be very careful. This is a slippery slope. So I suggest leaving everything to the attorneys. If they want an attorney to do it, most of the title companies have an attorney, or your tenant or landlord can do these things, but be very careful as an agent, because this could get you in a lot of trouble. You could get sanctioned for it, and you could possibly lose your license if you're constantly striking down, especially tenant rights. There's 5 pages to our lease that we're going to go over. Tenant rights in Florida are 5 pages long. There's a lot of legal information in there, so be careful you don't try to, as an agent, try to strike or add anything or delete anything from our contracts. Background credit check. The landlord determines that it's not acceptable, they can terminate the lease by refunding the deposit. The deposit does not mean the application fee, so I want to make sure that everybody's clear on that. If the landlord doesn't want that tenant, they can deny that tenant, and they do have to refund that deposit. And then you would request, just tell the department, the escrow department, you have to do a cancellation of contract form, and you send that to our escrow department. All parties have to agree to the cancellation, both parties, to get that money refunded. But again, that fee of $150 to the association is not returned. Okay, and this says within 7 days after receipt. So just make sure that they can't wait until 30 days and try to get that money back, cancel if they find a better apartment. So this all has to be done with 7 days after that if they deny the tenant. Failure to perform. This contract to lease is a legal document. A lot of people think that it's not, but you need to know that when they sign this, that they're agreed to it. I have clients all the time saying, can I make 5 offers? Because we're having a problem getting an apartment. Can I put 5 contract to lease offers in? The answer to that question is very simple. It's no. It is illegal to put 5 offers signing a contract to lease, because what if they say yes to all of them? Then the tenant or the prospective tenant could be held to responsibility for going into a lease with all 5 of those offers that they put out there. So if you have somebody that's looking at doing multiple offers on multiple properties, I suggest you putting a date on each one for that listing agent to get back to you with over, like if you have 5 properties, do it over a 5-day period. One on the 15th of March, 16th, 17th, 18th, and make sure that that agent knows that offer has expired after that date. So it's not a good idea, even though people try to do it all the time, to throw out 5 offers and sign 5 of these things. It is not legally responsible to do that. So I suggest not doing that. Do one after the other, let one expire, let the agent know it's expired, we're moving on to a different property. But don't have 5 of them signed out there with listing agents at one time. So this is the tenant's name, or the tenant's agent's name, which is Memo, and me. Make sure that everybody forgets to do this page because the names are there and they forget to do this third page for some reason, the second page. Make sure that that's initialed by all parties. And the third page is just where we have the tenant's signature and date. Again, if it's done by electronic, it's done time-stamped here. So it's all here. And you want to make sure that you check the dates are correct here, tenant's here, tenant's address. A lot of people leave this blank because they don't want the agent to contact that tenant and try to cut them out of the picture. It's supposed to be here. Legally, again, the address of your tenant is supposed to be on this document as well as their contact information. So I know a lot of people don't like to give this information of their clients out to other agents, especially if it's just an offer. But this information legally in the state of Florida is supposed to be here. So please take note of that. Do not leave this blank. If there's two people, you're supposed to have both of them here. Prospective landlord, same thing. Landlord's address. Again, I stress on here, the address, you can bring the address of the landlord is generally on the tax certificate. If people want to ask where that's from, it's on their tax information. Again, you can find that just by looking at the listing, tapping on the ID number or the tax ID number, and it'll bring up the address of the owners or landlords. You can put it right here, mailing address. And if you have that email from the agent, you can put it there. Again, for the state of Florida, they require this information to be here. And make sure again that they go right here and do your initials for everybody on this page. Even though they've signed here, they have to put their initials here. Okay, any questions, anybody about that? Memo, should we open up the questions? Hello?
Hi, Nanette. What about the prospective tenant address? What address goes there?
Wherever they are, or I use the one on their driver's license. It's a good idea. If they give you a driver's license, that's the address I usually put on here because that's really their legal address. Even if they've moved apartment to apartment, haven't updated their driver's license, I generally put that address there.
Thank you.
That's the best. That's the best and the most sound advice. And Nanette said, if they've given you, I would change that to because they've given you their driver's license. Always make sure that you have, and if you want to have a list of things that you should have before you are even dealing with a rental client, you can go to londonfoster.net under Office Manager, under Contracts and Forms, and there's an actual rental application and requirements, and one of them is to have a picture ID. Make sure that the picture ID, whatever name it states, that's what you're making the lease with. Whatever address they use, that's what you're making the lease with. A lot of times, me included, your legal name is Guillermo Valverde. I go by Memo. Memo does not fly in regards to legal tender. It doesn't work in a contract. So just because you go by a name doesn't mean that that's your legal name. You must use your legal name that appears on your ID. If the person is international and they don't have a Florida driver's license, then the passport.
Right.
Yeah.
The passport doesn't necessarily have their address on it, but you just, whatever legal document they're using, usually a driver's license, an ID card if they don't even have a license. The other thing with that, with the driver's license, make sure that it's not expired. I've had people, when I did a contract, I sent it to the, on their application, I sent that ID and I didn't look to see if it was a valid driver's license. So make sure it's a valid driver's license or the ID is a correct ID. That list includes, just since you brought that up, copy of
I was just gonna say real quick, before you get to the reading the list, guys, everything that's on that list is a very kind suggestion on what to put together. Do not make a contract to lease without IDs. Do not make a contract to lease without a credit check. Do not make a contract ID without a W-9, without a letter of employment. Don't do it. Because guess what? Nanette is competing against you, and she's putting it all together, and she's presenting that contract to lease with 7 different backup documents. So what's going to happen is that landlord's going to say,
A or B? B's ready to go. A, I have to write them an email and beg them for the next 2 or 3 days to get all this stuff together.
And thanks, Memo, for that. One of the good ideas that I always do before I even get in the car with a client, or they get in my car, or we meet at an apartment, whatever we do, I tell them to bring these documents to me before we get started. In our market currently, and here, I guess everybody knows we're on pace with New York now as the highest rents in the country. It's very, very competitive. Everybody knows this. It's no secret. Everybody from New York, New Jersey, California, Texas, every state, every country are moving to Miami right now. It is a very competitive environment we're in. So the more prepared you are, the more prepared your client is, the better chance that you're going to have one of these properties. There might be 10, 20 people looking at that same apartment when you do, and maybe 10 or 20 of those people, 5 or 10 of them are going to place an offer on it. So you need to be prepared. So you need to have a rental application. We have the rental application at londonfoster.net under the rental requirements. So have them to fill out that rental application, review it, tweak it if it needs tweaked. So copy of their ID for everybody over 18, copy of the first month's deposit made out to London Foster. So just be ready to go. If you don't know what that amount is, obviously, but you should have that deposit, have a proof of income. Like he said, 1 month pay stubs usually. If they're self-employed, the last 3 of their bank statements, and a copy of their 1099 or W-2. If they're retired, we have a lot of retired people here. They just need to know that you have 3 times the monthly rent. So it's very competitive here. You need to have all your documents in order. You can get a verification letter from your employer, stating your income on it, or from their work, pay stubs, etc. Credit report, you can get a free credit report at creditkarma.com. Don't waste your time if it's not a high credit score. Again, you're going to be wasting your time. And this is a way for you to prepare yourself and weed out those people that don't qualify, because I have a lot of properties that I personally rent out for my clients, and my clients are picky because they got stuck with people who didn't pay their rent for 2 years because of COVID. They're not going to do that again. A lot of our owners are sitting here in Florida who, the federal government protected them, the state of Florida protected them, and they didn't pay rent for a couple of years. So a lot of these people are now requiring, it's stiff competition, just to say. You can also get a copy of a police report over on Biscayne Boulevard at 151st. It's $5. So you can get one at Miami Beach. If you're in Miami Beach, the police department, you can go there and request. And this has to be done in person, and they have to have a legal document, driver's license, or a passport or something like that in order to get that police report. But you should have that. Now everybody's requesting it. And a reference letter from your most recent landlord. Because we had that 2-year stint where many people weren't paying, almost everybody that I'm finding is asking for that reference letter, that they were paid on time and paid the full amount, and they weren't in arrears, and they did not pay their rent. So that's very important. So just take a minute and look over those rental requirements, and send
Nanette,
that
we had
to
a couple questions in the chat, and
Yes.
I'll take the first one. The first one was, can you negotiate pest control? Nanette would tell you that everything in life is negotiable. So yeah, absolutely. You can negotiate whatever terms you want on the rent in regards to that list. But now let's be logical, and let's be pragmatic. If you were a landlord, would you want to be responsible for the pest control of a total stranger? No. Why? Because that tenant could be a total pig and leave all his food out and create a problem with rats or a problem with cockroaches.
Mm-hmm.
So no landlord is going to agree to that. Basically, take care of my house, clean up your mess, and if you don't, then you're responsible for taking care of that pest control.
Yes.
The second question was in regards to legality of foreign people renting. Guys, listen, there's a million ways of getting to one place. Nanette just mentioned the fact that there's a lot of owners getting a lot of offers, and you know what? They're not taking the low credit scores. They just simply aren't. They're like, you know what? If I've got 5 offers, let me look for the one that has great credit history and a great payment history. That's obvious. Now, can somebody with terrible credit rent an apartment? Of course. If somebody gives me the full year up front and they're going to pay me, you know, the monthly rent, yeah, of course I'm going to rent it. I'm going to rent to them. Of course I'm going to maybe, you know, negotiate those terms. Anything is possible. In regards to an HOA, most homeowners associations will require for the person to have legal status in this country in order to do a long-term lease. They're also going to require for them to be employed. So they're not going to look for people that are on unemployment to rent a $3,600 apartment. And that has to do with the HOA's, what's the word, prerogative to say, you know, first right of refusal. We don't want this.
Thanks, Memo. As far as the pest control, I want to touch on one other thing. I have a client who is an owner. She lives in France. The building does the general areas and the common areas. The building does pest control. You can check again. This is one of the questions to ask the property manager. Hey, do you guys do common areas, or do they actually do, sometimes some buildings will post like once a month or once every other month, they'll do pest control. They put on the bulletin board somewhere or a notice that says, hey, the pest control will be here between 8 and 10 if you want your apartment fumigated or if you want serviced for pests, then they can do that. Most buildings do not go inside apartments because people are allergic or they have a pet or they have a child and they don't want it. However, it's the responsibility, and I've told my owner, because she had a company, they were charging her a lot because her cabinets had termites and they had cockroaches in the building because they had a lot of renters and they had a lot of cockroaches. So she said, I want the tenants to pay for this. And I said, that is a huge, huge mistake. And this is my personal opinion because it's her property. Does she want termites eating up her whole cabinets and her whole apartment while she's away in France? The answer is no. It's about protecting your property and your investment in your assets. So I suggest all owners should do pest control just for the reasons of that singular apartment that I deal with. She has termites. Termites can, are eating up the cabinets. It's up to her to get rid of those. The tenant is moving out in a month or so. He doesn't care if termites are eating up her apartment. He doesn't care if there's cockroaches there. He's traveling all the time. He never sees them. But it is a good idea to have your owners, if the building doesn't do interior unit pest control, to have some kind of pest control in place. So I would not rely on tenants to do pest control. They're just usually not responsible. It's costly and they don't want to deal with it. It's not their investment. That's why they're renters and not owners. They don't want a lot of that responsibility of, washing machines breaking down or dishwashers and things. They're tenants. So we need to treat our properties, if you're an owner, as your investment. Okay. Enough about that. We're going to move on from the contract to lease to the lease. And I'm sorry, we're looking at 1054 right now. So we're going to scoot through this. The first thing is, if everybody will bring it up, it's on the screen, the non-disclosure, very important. Any information that you give to a tenant, to another agent, to the owner, you're not a lawyer unless you really have a law license. Agents generally are not lawyers. We cannot give out legal information. We should not give out legal information. Be very, very careful about doing this. So when you fill these documents out, remember that you're only to fill in the blank spaces and you're not to add information or take out information. So this is all just mandated by the state of Florida. So again, I always fill this out. I always fill this out. Oh, one other question. Let's back up. Somebody asked me about a foreign, before we get into this, about a foreign person, what documentation. I have a lot of foreign tenants and foreign owners. It's up to the owner and to the building what information they take from a foreign tenant. Most of them, when they do a background search, it's going to be more expensive than the US background search. It's going to be because they do an international background search. And they don't have, in most countries, they don't have the documents that we use here to do the background. They may not have the credit score. They may have no credit at all. And sometimes I tell people no credit's better than bad credit, but they will ask for sometimes more rent up front, 6 months up front, sometimes a year in advance. If somebody has no credit, you're taking a big chance, you know, and also if they can supply any kind of work documents, anything from where they're working or pay stubs, where they're working, references from professional people that they work for or other places where they've lived. As much information you can supply may be helpful. But usually it's between the owner, if the owner's going to accept these people, and it's the tenant, whatever they can work out. And as much information that you can gain from a foreign tenant, the better off you are. Legally, in the state of Florida, a property manager and an owner cannot discriminate, because if you remember our acronym Fresh Corn on discrimination and the Florida law and the US law, you cannot discriminate who moves into a building, an apartment. You can't discriminate. The only place that you can change those rules is if it's a 55 and older community, and they do have to prove obviously that they're 55, but they cannot discriminate from what country you're from. And I've had this situation personally come up with some property owners and also with some managers, and I always just refer them back to the state of Florida and the US rules for property. They cannot deny those people. They can deny them because they have no credit. They can deny them because they have bad credit. They can deny them because they have a criminal record, but they cannot just say no because of where they're from. So keep that in mind. The law is their best friend here. It protects tenants and it protects people moving in. So anyway, let's move on to the lease. So put your name here. And I want to point out a couple things here. If they can read English, check I can read English here. And if you're doing it online, you can do in the e-check, there's a check mark there. So you want to make sure that. If they cannot, it was read to them by you or whoever read to them. So anyway, then you want to have them sign here. If there's more than one landlord, have them sign here, have them sign here, and then also do another signature here and another signature here if there's two tenants. You want to make sure everybody signs this. It's very important. And the licensee is the other agent. So if the person, if I'm the listing agent, which in this case, I'm the listing agent because I filled out my name on the non-lawyer disclosure that I'm not a lawyer, then the agent bringing the tenant is considered the licensee. So that's where the licensee, he or she, signs here, not you, if you are the listing agent. And again, the listing agent, I'm considering myself in this example, the listing agent. So I'm filling out the form and I'm making the contract. Okay, so then this lease is not for a house. We have a different lease for a single family home, and we have a different one for a duplex. So, and you'll find that under our forms at londonfoster.net. Under forms, you can find this lease as well as the other leases that we have, the ones for single family homes. Just keep in mind, this is for an apartment or a condo. Okay. So I suggest on this, just like I did on the contract to lease, try not to leave any blank spaces, even though it says you can leave them. You want to leave all you want to put everything here so there's nothing to question or to say, hey, you left that blank. So I don't like that kind of situation. I like everything to be clear, to be black and white. And I do like to fill in all my spaces, even if it says left blank. So keep that in mind. We don't want anybody to have a question or to be able to fill in something that you did not fill in. So, which is really the reason I do it. I don't want somebody to go back and fill that in when I didn't have it filled in already. So this lease is coming straight from our contract to lease, and the information is being transferred. We're doing a 12-month lease starting April 1st, ending April 30th next year between the two parties, Jane and John. Again, here we have the landlord's email is here, the landlord's telephone number. The reason this is here is if you were to go on vacation, if you were to go somewhere, or if something, heaven forbid, happened to you, the tenant has a copy of this and the tenant needs to be able to get a hold of their landlord. If there is a landlord's agent or a property manager, that information might go here. But again, the state of Florida says it's the landlord's email address. You're not really supposed to keep this stuff private. It's supposed to be legally on here. landlord's email address, landlord's telephone number, the tenants. If there's more than one tenant, there's space if you do e-sign, so you can put 2 different phone numbers here. There is space here, maybe not 2 different addresses, but you can put it to the side if there's 2 tenants. Again, this last 2 years have taught us a lot. So, you know, we may have had people in the hospital. We may have had people pass away. So this information has to be here in case the tenant moves, the tenants or the owner relocates. This information should be updated and changed, and the tenant should know also this information is here because that owner is holding their security deposits, and those tenants have the right to know where and how to reach the landlord if they want to move, if they want to renew their lease for any reason. They need to call hold of the owner. That information should be here, and vice versa. If the owner needs to get a hold of them, for instance, what if they had something happen in the apartment? They might call the agent, but the agent may not be responsible if their dishwasher is broken. They need to know how to get a hold of that owner. And if, you know, if there's a fire for whatever reasons, this information should never be left blank. So I just want to point that out. We put the address of the apartment we're going to rent. I just put our office so you guys know where our office is. We're located in Miami Beach at 407 Lincoln Road, Suite 10G in the Bank of America building, 33139. And this is where you write the information that's included. The stove, the refrigerator, dishwasher, microwave, washer, dryer, and window treatments. So this information basically is what the owner has in the apartment. If there's furniture, because there's only 3 lines here, I usually do a 1-page and I write here, see attached furnishings. So, and you go over that list at your walkthrough with the tenants and with the agent or the owner, whoever's doing the walkthrough at the end. You need to make sure that all this stuff is here at the end. When you do your walkthrough at the end, everything is there at the beginning. So again, you can put see attached furnishings here. And when you do that attachment, that becomes a part of the lease. The furnishings become a part of the lease. So it also has to be initialed by all parties if you do that attachment. Okay, if there's nothing in there, then you write none. If furniture and appliances, it's empty, you write none. So there's probably always going to be appliances. So just again, when you go through the apartment, when you're viewing it, make sure there may not be a dishwasher. That's a big thing to some people. It's like, wow, I don't know if I saw it or not, but just check when you're there, make a note of what appliances are there. Maybe there was a countertop microwave and it wasn't built in, and maybe that microwave belonged to the previous tenant and that tenant was moving. You know, maybe you saw it when the tenant was there. So just make sure that everything is in there, everything is going to stay. Window treatments. Maybe there's a tenant who has it's their own curtains and there's no window treatments. You get there, wow, I thought there was a blackout blind and I thought there were curtains and they're missing. Well, it's because you didn't do your job and make sure that everything stays in there that was there. So you need to make sure with the listing agent and also when you view the apartment, what should be in that apartment. Again, we're just going to go over the rent section for common areas. You get used to the common areas. Here is just number 3. That's pretty easy. Whenever you move into an apartment, if there's common areas, you should have permission to use those. The rent payments and charges. On our case, again, we're going to do a $3,000 amount of rent, which we brought right from our contracted lease, and our rent's going to be due on the 1st of the month. Each month. Again, it's not a short term. And in this case, this example, there's no taxes. If you do a short term or if it's a hotel condo situation, there may be taxes here. So you need to make sure of those taxes. The listing agent should be able to tell you if there's taxes there and should be able to put that amount in. Make sure, again, I'm just going to repeat this, but the tenants, if there's 2, one goes in one parentheses, the other tenant here, landlord, if there's only one, they do the first one, and if there's 2, they do the second one on each page. This page it's 18 pages long, this lease. If you're moving in the middle of the month, this is where you put that. If it's not the 1st of the month, or if it's a prorated situation, that's where you would put this date here. If tenancy starts on any other day of the month or week, This is where you put the prorated amount. Like if they're moving in on the 5th, we happen to be moving in this example on April 1st. If I were moving on the 15th, I will put April 15th, and that rent is good for April 15th through April 30th, and it would be $1,500, half a month of my $3,000. So that's where you would put this part. And we always use 30 days here, even though there's 31 days in a month, in some months, and 28 in February, we always do the prorations based on a 30-day month. So this comes straight from your real estate license. We don't use 31 and we don't use 25. In real estate, we always prorate 30 days. So again, if for instance, example, my rent is to $33,000. If we move in on the 15th, it's $1,500 through the April 15th through the April 30th. So here, and that the next rent would be due on May 1st. Security deposits. We took this information exactly from the contract to lease. The tenants are giving a security deposit of $6,000. That's put here. Advance rent, they're paying the first month up front that they gave already to London Foster. That's our deposit, but it's still advance rent, $3,000. It's for 4/1/22 to 4 here. This is an additional month in addition to the deposit, the first month. Pet deposit of $300. Again, that's taken exactly from our contract to lease. Late fee. Everybody always asks about this. If the rent is due on the 1st, I usually give everybody till the 5th. Why do I give them usually 5 days? Because of weekends. If you have a 4-day weekend and the 1st of the month happens to fall on a Friday, if they get it there after noon or 2 o'clock, the bank may not process that payment. So I always give them 5 days just because of the chance that some of those months in that year may have a fall on a 5-day weekend or a holiday. So I usually give 5 days. You can give, I wouldn't give less than 5 days. You might want to give more, but basically 5 days, they should be able to make it even if the banks are closed. Because remember, on legal holidays, bank holidays, the banks are closed and some of those transactions may not be able to be made if they're paying electronically. So, and I want to point out something here to people who pay electronically. Each bank has a time period of when they send payments. I particularly always like to check with my bank. I pay my bills electronically for my bill pay. When I do bill pay, my bank takes 3 days to get it anywhere. So I build that in to when I'm making my payments. If it's due on the 1st, I try to make sure that those 3 days are included in that transfer and that I do it, so it's going to be there on the 30th and not on the 1st, just so I don't incur any kind of late fees. But anyway, this is important when they're doing it, especially if we have holidays and weekends. So just make sure whatever payment the tenants are using, electronic payments, bank payments, bill pay, Zelle, whatever they're using, to check on the transaction time to make sure that they don't get late payments. And this says $50 for each lease payment made more than 5 days. It's not per day, it's for per payment. So sometimes people say, oh, $50 a day. No, it's for each lease payment made than 5 days after it's due. So it's not a penalty daily. A bad check fee. Check to see what your bank has for a bad check fee or a bounce check for the owners. My bank, I think, charges, I don't know, $30 right now for a bounce check, but it's not to exceed 20% or 5%, $20 or 5% of the lease payment. So if it's $3,000, you just want to make sure that it's not excessive. So do the math and make sure that it's not an excessive fee. For me, it's a deterrent. I always usually just put $50. I don't know of any banks that are charging a bad check fee and $50, but it is an inconvenience to the owners. And although I said my bank personally charges $30, I put $50 just as a deterrent to make the tenants be aware that they're going to be charged a fee if it is late. Anything else?
Then somebody just asked a question in the chat. Do you want to look at it real quick?
Sure.
He's asking basically if something happens, like let's say there's a construction outside or the pool has been closed because of construction or any other, amenity that has been interrupted in the service, and the key word is can the tenant request a reduced rent?
This
It's a
is
trick question.
yeah. So to answer that question, they can request it. Legally, you cannot withhold rent from your owner if any situation like that has happened. Even if that washing machine or that washer breaks down, you still cannot withhold rent. Your lease does not allow you to withhold rent. Can you negotiate? The answer is yes. Again, my question is always yes, you should be able. It depends on the owner. It depends on the owner. If the owner
And
wants,
the key word is can. The key word is can.
Right.
Can you can request anything you want. The
Right.
owner does not have to agree to it. The owner does not have to reduce your rent. The owner is under no obligation. The only thing that it says there is peaceful enjoyment. The pool is not peaceful enjoyment of the
Right.
and neither is construction. And neither is, and I know it's hard to believe, but neither is construction outside of the building. Even if it's rattling from 9 to 5 p.m., that is not peaceful enjoyment. Peaceful enjoyment means like there was a flood and there was water coming down your thing, or there's mold, or you know, it has to be something like extra super normal, abnormal, or whatever. But on that same note, just so you guys know, I've done this so many times. Sat in front of a judge, in front of somebody who withheld rent or did not pay the rent. The very first thing the judge asks the tenant is, "Are you current on your rent?" "No, but Your Honor, the thing is that my grandmother's cousin's left, you know, nephew." And no. "Are you current on your rent?" No, but you don't understand. The landlord is a monster. No. "Are you current on your rent?" The moment you say, "No, I am not current on my rent," the judge turns around to the landlord and says, "Do you want him in there? Do you want him out?" Because that's the very next step, is he will evict you in a matter of 10 days. So
Yeah.
if you want to stay in the apartment and you want the judge not to turn on you and to think that you're a bad person and therefore always pay your rent, you know, you have legal documentation saying all the complaints that you have and that nothing has been addressed and this and that and whatever, everything else. But the very first thing the eviction judge is going to ask you when you sit there in court is, "Are you current on your rent?" And when you say, "No, I haven't paid rent in 6 months," the judge is done with you. They want nothing to do.
And going back to that question, if it's something that makes the apartment unlivable, it's one thing. Unlivable as in the water is turned off, not because you didn't pay the bill, but because of the building and there's an emergency. I have a situation right now where the balconies, people rented all these apartments with balconies looking over to this beautiful park. The city of Miami Beach just screwed their, literally they screwed the doors shut, the city of Miami Beach, to the balconies because they said the balconies were unsafe, and they're redoing their balconies. So these tenants want a reduction in their rent. I have 2 tenants in that building, and each one of them worked out with the owners because it's an inconvenience. An inconvenience is not unlivable. So don't think that noise from the trash truck on the back alley banging around every morning at 5 a.m. and honking their horn and making people move their cars and all this noise, construction, etc., that is not making an apartment unlivable. It may be inconvenient to the tenant, but it's not making it uncomfortable or unlivable. So those are 2 different things. So I would say you can ask and you can say that it's inconvenient or that it's a nuisance. But the bottom line is, like Memo says, if you're sitting in front of a judge, you can't stop paying your rent, number one, because the lease says you have to pay your rent. Even in such situations, you still have to pay your rent. You may ask for a reduction in the rent. They can say no, or you can be nice about it. You're a good tenant. You're paying your rent every month. They might say yes and work something out with you. In our situation with the balconies, during the period that the balconies are closed on that particular apartment, both of the owners agreed to do a decrease. I think it was like $50 or something for the balcony. But again, remember that the situation that we're in right now in the beach and in Florida in general, there's 10 more people waiting outside that want that apartment, and they don't care if that noise is in the alley or not. They don't really care. The condition is not perfect in the apartment or if that microwave is working. So keep in mind before you go screaming and yelling, or your tenant goes screaming and yelling at the owner, what are your choices? Because that owner—
That's a really good point, Nanette. That's
Oh,
a
yeah.
really good point. I just had someone that came to me and said to me, oh, I need to get out of here. I hate my landlord. She's
Yep.
awful. She's this, she's that. But you have to find me a 2-bedroom for $1,800 in South Beach. I'm like, bye.
Good
You know,
luck.
yeah. You know
yeah.
what? If you got an $1,800 2-bedroom in South Beach, you know what you do? Shut your mouth and
Yeah.
thank God, and you let it go. Yeah, no, that's a great point in it.
The bottom line is that everything is negotiable and may be negotiable if both parties agree on it. And that's what our contracts are all about. It's big, it's a negotiation. And the sweeter you are with your negotiations, the more benefit it's going to be to all parties. Because if you go in with gangbusters and you make a lot of demands or unusual demands, you're probably going to get passed over for another agent who's sweet, just like me. So be careful. I mean, be careful with your demands. Make sure the tenants are responsible. But back to that question, legally, you can't withhold the rent. But you can ask for some kind of a reduction, and yes, they may or may not. During COVID, and people had lost their jobs on an individual basis. I had tenants asking for a lower because they had lost their job or their job was cut back to 3 days. And rather than that apartment sit vacant or have a tenant not paying at all because they lost their job, they did reductions in rent. So again, you can ask and may or may not. In this current market, I would say not a lot of negotiation going on. The only time that a rent, just so you know, this came up a question that we had yesterday from someone. When can and how much can a landlord raise the rent? In the state of Florida, there are no rent caps. There are no rent caps. However, if you have a lease, the owner can only raise your rent on renewal of that lease. They cannot just in the middle of a 12-month lease right now because they see everybody else in their buildings getting $4,000. If you have a lease that says $3,000, that owner is responsible to honor that lease until that lease expires. Now, when they do a renewal or you go to renew as a tenant, if everybody's doing $4,000, they're probably going to go to $4,000 or greater and get the highest. They're going to take the highest bidder for that property. But
Nanette, that's a great point. And on that
there's no
same
cap.
point, I actually saw this the other day and I started laughing. I saw an agent that did a lease
Mhm.
and then did the renewal with the lease. Guys, that's not legal. In Florida, you're only allowed to make a lease 1 year long. You
Yes.
cannot make a 2-year lease. If it is, it has to be done by an attorney. The agent has to be relieved of his duties, and he is not involved in that. As a Florida licensed realtor or real estate agent, you are not permitted to make a lease longer than 1 year. And no, you cannot make the subsequent renewal with it. It invalidates the moment you create it, it's invalidated because of the date. So in
Right.
other words, like like Nanette is saying, the first lease expires. Oh, but I already have the renewal signed and executed. Guess what? If the landlord doesn't want you there, he can evict you. Oh, but I have this. Nope, because it was predated of the day that before the day of the lease expiring. And I know this from the legal department. So
Yeah.
just don't make your life miserable. Don't make your life complicated. Don't try to reinvent what's already there. You cannot do that. And more importantly, that's there to protect the landlord, because heaven forbid the landlord gets a horrible tenant. He can say, you know what, I can't throw you out through any of the other circumstances, but I'm going to throw you out through this. Your lease is expired, and he doesn't have to give an explanation why he doesn't want to renew that lease.
Mhm. Good feedback there. Thank you, Memo, for that. So security deposits. Let's move on to section 6. So this is just to do with security deposits. So most landlords that I know, they have a bank account. They're supposed to have a separate bank account for their properties, and they're not supposed to commingle it with their personal funds. I don't know. I mean, we have to tell them that they need to do that. So they're supposed to have a separate bank account. It's not an interest-bearing account, and so tenants are not going to be interest on it for the most part. They don't gain interest on rents. So when they move out, their deposit is going to be what they paid if they don't have any damages. And the same thing with the security deposit. They're going to get back what they paid. They're not going to get any. In Florida, most people don't do interest-bearing accounts any longer for their properties. So anyway, that just explains that part. So I just don't know anybody that does interest bearing. If they do, they're probably not going to pass that on to the tenant they're going to keep that interest for themselves and just give that back. But I don't think any tenants are going to be able to get any kind of interest off of that money. Notices. This is important. Section 7. The owner, generally on all my leases, I try to make the owner responsible. If you take it upon yourself to be responsible, you're taking on a lot of trouble, a lot of phone calls, a lot of issues legally. So if they have a property manager, that's where their name would go. But if you have the owner's name needs to go here. So again, the owner of this property is Jane Doe. She's put there, and generally the lease payments will be sent to, if they're going to be electronically sent, and this is what all my clients are doing right now, I write here, direct deposit to owner's bank account. And I usually don't put that on anything in writing that everybody would be copied on, like this lease to everybody. I just put that we're going to give that account at walkthrough. And I hand, when we do the walkthrough of the apartment, when they get the keys, I hand the account number to the tenant. So there's nobody, this bank account, because we have so much fraud all over the place right now. I try to protect my clients' account numbers and stuff by only giving it to the tenant or where they're going to make it. If they want it deposited directly to a bank, they still going to need that owner's name on that account. Not if it's an LLC bank account, the LLC has to go on it, not their personal name. If it's their personal name on that account, that's what has to go on the check to be deposited at any banks. And again, we talked about this before. Tenants cannot take cash to a bank any longer, and banks don't even accept cash from a third party. So if a tenant needs to make it either in a money order or a cashier's check, if they're paying directly to a bank. If they're doing electronic, they can do bill pay or just send it by Zelle or however they work it out with the owner. But if I were you as an owner, as an agent, I would let the owner do all this negotiation and all these decisions and stay away from it. You are never to accept cash from any tenants. You're not a rent collector. You should have the owner work this out with the tenants and stay away from this, because money could go missing, fraud could happen. And obviously I need to say this because somebody actually asked me this. They have a foreign owner, and I don't even want to say what country it is, but that owner expects them to collect their rents, deposit in his account, and transfer it. Never, ever, ever, and I shouldn't even have to say this, but you never, ever put a tenant or an owner's money in your own personal account. That is not legal. So it either goes into as escrow to London Foster directly, or
It's actually the definition of money laundering.
Exactly.
Literally the definition of money laundering.
Right. So stay away from these. Do yourself a favor. You want to keep your license. Don't even think about it twice. Just the easy answer to your owner, to the tenant, is no, that's illegal. I cannot do that. So just stick with that and you'll be okay. Okay. If they need to give notice for the tenant for non-payment of rent or anything like that, it needs to be done by certified mail. Certified mail of the known address of the tenant, and that would be the one on their driver's license, like we said before. If it's at this apartment, then it would be the 407 Lincoln Road. It has to be done by certified mail with a return receipt requested. This can be done at the U.S. Post Office. So it is not legal notice to send a text to a tenant. If you're going to try to impose any claim, you have to do this the legal way. If you ever go to court, they're going to ask for the documents, the legal documents. They're not going to accept your text. They're not going to accept your email. It has to be done exactly as it says on here. Any notice to the tenant or to the owner, if it's vice versa, it has to go through that certified mail. And that's why it's important to have that owner's name and address on our contract and have the tenant's known name and address, just for this purpose right here. If you run into problems, you need a physical address, and you need to have a physical address and a phone number and an email for all parties. But again, anything going back and forth is basically on text. This isn't Judge Judy. This is the state of Florida. A text is not going to be permissible, and they'll ask you, show it to me in writing and give me your contract and give me the documents that were certified mail. So if you go to small claims court, the first thing they're going to ask the owner for is, where's your documentation that you sent to this tenant? So make sure you get all your ducks in the row here. Says the same
Miss
thing.
Nanette,
Yes.
I'm sorry. Someone just asked a question. Yeah, this is somebody was asking in regards to when the lease expires. Does it go on a 30-day? Absolutely. The moment that a lease expires, it goes on a recurring 30-day lease. The reason why they do that is obviously because you didn't do your job. You should have gotten a renewal fee. You should have been involved in the renewal.
Mhm.
If for some reason it did not happen and the lease expires, that doesn't mean that the owner can show up the next day and say, hey, get out of here. As long as they're paying their rent, you can't evict them. The lease regenerates, but only this time it's for 30 days. Now, what does that mean? What that means is that if the lease starts on the 1st, by the 30th of the month, they have to be out. The tenant has to give 15 days notice, and so does the landlord if they're planning on not continuing the month to month.
Mhm.
So what does that mean is basically, if I have my client, if I have a tenant on a month to month, and I say I want him out on the 1st, on the 15th, I have to send him notice. Like Nanette said, a text does not suffice. It has to be an email. It has to be in writing. So my recommendation is, if you're helping the owner, is write the letter, to make sure it's mailed, certified, and also send it to him as an email.
Mhm.
And that way that person knows. But it's not the same as a normal lease. Remember, it's month to month. On a normal lease, the standard is you give 30 days. Sometimes the lease even says 60 days. On a month to month, the owner could basically get you out of there in 2 weeks.
Yes. And also with that said, what we were talking about raising the rent, if they're on a month to month, the owner can raise the rent. If you're in a 1-year lease, they cannot. So the 1-year lease protects the tenants more. I can tell you it protects the tenants so much more. So if you are representing the tenant, or if you are a tenant somewhere, you have a 1-year lease. These ones who are not, I have a guy who moved 6 years ago into an apartment. He was paying $1,250. It's in a little apartment up in North Miami. He has no protection because they did one lease. He's never done another lease. The person is that he pays to a bank account that's the owner is in France or somewhere, and he has no protection. And they're selling it now. So they want to sell it. He has no protection. He says, well, do I get 30 days to stay here? Do I get 60 days? Do I get 90 days? The answer is no, they need to give him. And you'll see also, if you read the rights, there's 5 pages of tenant rights in here and landlord rights. Those rules all change when you do not have a 1-year lease. Those periods all shorten. So basically he just has noticed that an agent showed up and said, I'm listing this apartment. I want to show it tomorrow. It's for sale. That's how he found out after 6 years. And what do you think the chances of somebody paying $1,250 for a 1-bedroom, 1.5 bath are going to have for getting a rent in a hurry? It's going to be very difficult. He's out of the market basically. But anyway, if he had had a lease, at least he would have had time. If he had a 1-year lease, a written 1-year lease, and that's a key word too, I want to point out, even if it's 30 days, get everything in writing, Don't just, have a lease, even if it's a short-term lease. If that owner says, hey, I want to put you on a month-to-month right now, get a month-to-month agreement with that person that they're not going to kick you out tomorrow. Because the truth of the matter is, if you are late, if you don't have a good paying record, if you are not paying your rent, they could get the sheriff to do a 3-day notice of non-payment of rent, that you have a day or two to get back to them to pay that rent, or the sheriff can ask you to move out. So if you don't have a lease, it's a very scary situation. You should always have something with that owner in writing. And I suggest at least a 1-year lease for those people. So, okay, so let's move on. So we're going to go down to the next page. Overnight guests, occasional guests, 7 days. I usually put 7 days. You need to verify this with the condominium association, because each condominium association has a rule about overnight guests. Some say 8 weeks. Some of the 55s and over say, hey, your family can come for 6 weeks or 8 weeks. Other ones say 7 days. Other ones say no longer than 14 days. Again, you'll see where this says if left blank 7. This is really, really an area where you should not leave it blank. This needs to be there because we all, if you live in Florida, you're going to have guests because everybody up north wants to come and hang out and stay here. So this needs to be in writing, and you need to verify how many days a person can stay with the association and go by their rules. In any leases, no matter what we put on here, the association will trump our lease. So the association rules, they can overcome the agent or the owner's rules. So the association has priority, and their rules are golden. Even if the owner would let somebody stay longer, the building says no, the building would rule. Okay, this one says a pet deposit, the next thing. In my example, we're allowed to have a pet, so that's why I check that box. If there's no pet, you don't check that. Unless this is checked, smoking is permitted. On my lease, I put prohibited on my contracted lease, so that's not checked. If you have a smoker and they allow you to smoke, again, check with the association. And this is a very tricky thing. If the association now has non-smoking building or no only smoking exterior of the building, no smoking inside units, you need to know this. You can't put a smoker, a chain smoker in an apartment if the building doesn't allow it. And like I said, with the pets, like I said, with the guests coming there, you need to check the rules of the building and apply the rules of the building to each of your leases. The other one's a given. Flammable objects, you're not allowed to keep anything in there for fire hazards. This always comes up too when people have a gas grill on their balcony. Florida doesn't allow gas grills on any balconies, with the exception of a few buildings that have larger balconies that they may have built-in ones. But for the most part, they do not allow any cooking on balconies in most of all the apartments that I go to anyway. That very high-end ones and townhouses may have this. And but again, check the rules of the building, go with the rules of the association, and don't let your tenant fall into problems with this. This is just general rules here about the tenant responsibilities, and this goes into more in depth in the 5 pages of the tenant landlord rights. So I'm going to kind of move over this a little bit. The next part, maintenance. This is really important. So this applies to the apartment itself and to the association and the amenities. Elective maintenance. Fill in each blank space with landlord or tenant. This is very important on who does what. Okay, smoke detectors. Usually the physical smoke detector, the landlord in Florida is responsible for having smoke detectors in the apartment. The tenant, however, may be responsible for doing batteries. So basically let your tenant know, yes, there should be a smoke detector, and there's usually one in the bedroom, one in the kitchen, or in the living room. So there's usually 3. If it's in a 1-bedroom apartment, there may be as many as 3. So you need to make sure when you do your walkthrough that those things are functioning too. Again, with all the properties that I have, I usually once a year, I check these smoke detectors. It's usually when the time sets back, like we just said, the time set back. I made sure that all the batteries were replaced. I just annually replace them in any of the properties that I have, that I kind of watch over, manage. Extermination, we asked this, we talked about this. I always usually put the landlord, again, because it's the landlord's asset. The landlord should do this. And again, even if the building does, they only do common areas usually, or they have a day of the week and that they're going to do it, or once a month, but you can't rely on the tenant being there during those hours. And you can't rely that they will actually open the door and let the exterminator in. So generally, rule of thumb, I put the landlord responsibility. Locks and keys, very, very important. I live in South Beach and Memo lives in South Beach. How many people have come in at night, they've lost their keys, they can't find them, and they want to call up the agent, or they want to call up the landlord and say, I need a key to get in, or they want to call up the management. Okay, I'm not responsible as an agent for the keys. The owner who lives in France or Brazil is not responsible for letting that tenant in. That tenant is responsible for having the locks and keys. If they have to call a locksmith at 4 a.m., it is the tenant responsibility to pay for, repair, and do whatever they need to do. It's the tenant responsibility for the locks and keys. Obviously, at walkthrough, when we take possession of the property, we get the keys to the apartment. Each person should get a mail key, 1 mail key or 2 if there's more than 2 people, but they may not have 2 keys. So you're responsible for giving or receiving 1 mailbox key, door locks, to the front door if there's a front door, to the back door if there's a back door. So at walkthrough, these keys should be exchanged. If there's a common door that doesn't have a fob, then the owner is responsible for giving an entry key to that building. It's usually one of those Medico locks or keys. I mean, because most of the entries to the buildings and if they have an entry to the building, a main lobby, they have a special lock on there that you cannot get copied. So the owner is responsible for that. The association may charge $25 or $50 for this key to an owner, but the owner is responsible generally, unless it's worked out otherwise, that the tenant has to pay for that, or a tenant has to pay for a fob unless otherwise notified. The tenant should have a mail key, front door key, and building key in general. However, if they lose those keys, the tenants are 100% responsible. If they lock themselves out, the tenant is 100% responsible. So make sure that this is on there, locks and keys. And this means after we get the keys at the beginning. Clean and safe exterior, landlord, because that's the building. Garbage removal, if garbage removal is included in the rent, and it's usually included if it's a condo in the association, then garbage removal outside of the unit is landlord's responsibility. Running water, hot water, the lawn, again, we're talking about a condo here. We're not talking about a single family home. All of these things can vary if it's a single family home. If it's a single family home, usually running water and lawn and garbage can be the responsibility of the tenant. So you need to make sure when you go in, and again, don't rely on the listing, ask the listing agent. And if there's an association, ask the association on what's included for the tenant to owe each month. Heat. Some of the condos in Florida, they do not have heating elements in their air conditioning if it's a central air. So this is something that's on an individual basis. You'll have to ask, is there heat in this apartment or not? It always comes up. If you're renting an apartment in July or August, you don't really think about it. But in January, when we had 40 degrees, it may be important for the tenant to have heat in the apartment, but not all. Even if they have a central air conditioner, that heating element may not be in that unit. For fire hazardous reasons. Sometimes they leave them out because they're never used and can cause smoke in the apartment. And anyway, but just see if it's heat or in the apartment or not. Air conditioning, this is talking about the unit to make sure it's working. And this is individual too. If it's a wall unit, it's still the owner's responsibility to be functioning. So that's landlord. Furniture, if it's furnished or not. In my case, in my example, it was an unfurnished apartment. If it has furniture in it, the landlord's responsible for that furniture. And you are responsible for the condition, which up here it says you have to keep, a reasonable working order. And if it's furnished, they have to keep the furniture obviously in working condition and make sure that it's clean, basically. Appliances, generally, and again, this is in a condo, usually the landlord's responsible for all appliances. A tenant in single family homes sometimes are responsible for some of the appliances, especially if there was a washer dryer, it will say washer dryer hookup. And in that case, if it's a single family home, the tenant would be responsible for that. Fixtures. Fixtures are usually considered lights or fixtures. Window treatments are fixtures. So if those things are there, and the landlord has them provided, then you check the landlord. If they're not there, I mean, all of the condos are going to have lights in them, of course, but this may vary if there's curtains or blinds. And it varies apartment to apartment, house to house. The pool, if it's a pool that, again, it's at a condo, the landlord, and this goes into the amenities for the condo association. So the pool, the landlord will be responsible for that. If it's a single family home, obviously, they're probably going to make the tenant be responsible for the filters at least, and making sure that it's in running condition. Heat and air conditioning filters, this has been added. This was added last year. It was never there. We always had to write it in, but heating and air conditioning filters, again, they can pick those up in a 3-pack at Home Depot. They can get those at Navarro's. They can get them at Publix. Just check the size of it on your AC unit and make sure that they're changing those. And some of the filters are 1-month filters. Some of them are washable filters now. Some of them are 3-month filters. So just make sure the tenant knows that they're responsible for this. It goes to the air conditioning running and functioning properly. So it's to the benefit of the tenant for it to function properly, to make sure they change these, especially if they're a smoker or if they have pets, they need to be changed more often. The tenant responsibility, other. I always put condo insurance for tenant and guest contents. The reason I write this on here is because most of my owners, they don't want to be responsible if the condo above leaks and floods their apartment for the contents, the owner's stereo, the owner's clothing, the owner's computers, etc. So, or if the apartment is broken into. So this is very important. I always put this on here, and effective condo insurance for tenant and guest contents. Anybody can go on Progressive or on, when you rent, they can go on and get a policy for like $10,000. It goes by a dollar amount from Geico or Progressive or something for renters insurance. So if you have tenants, I suggest they do get renters insurance just for, you know, hurricane damage, if the window may come open or a door, et cetera, to protect their private and their guests' contents. So the owners and the building insurance will not cover contents. So the building insurance covers walls out. So this is for insurance covering walls in. And if you have a tenant, the owner does not want to be responsible for any of the tenant's contents. So this is important, and to make sure that it's effective. Most of the owners that I have, they require a picture or an email from the actual insurer saying that this person is covered and the amount that they're covered. So let's see, moving on down here. Landlord shall be responsible for major maintenance of major replacement of equipment. This is such as AC, kitchen appliances, etc. And a tenant has accepted responsibility for repair of no more than $150. Why do I put $150? It's typical. You can, the owner can put whatever amount he wants on here or suggest an amount, but also the tenant has to agree to that. I put $150 because if I call an AC guy, he has to come out and repair the AC or do something like that, or he has to come out because the food disposal is backed up, or a plumber has to come out because something is wrong. They're going to usually charge you $150 at least for any little thing they do. Usually $75 to come out, and maybe $75 or $100 to fix something smaller, which this means anything over the $150, the landlord would have to pay for that. So this can be contentious, that people can argue about this, but I usually don't put something excessive, and I don't consider $150 to be excessive. And it also is a deterrent to keep tenants from complaining about every little thing that breaks down, like the handle on the blinds broke, or, you know, some little something. And also keeps them responsible for keeping it serviceable, clean, and not to stick stuff down there. Toilets, not that shouldn't be going down there, and not to put stuff in the food disposal that's going to jam it up. This makes people a little bit more responsible if they know they're going to have to pay for that service call. I suggest too that owners get some kind of service policy with a company that they just pay monthly or annually for the large appliances. If there's any issue, you can find online, and also on our vendors at londonfoster.net. There may be some companies on there that do maintenance, appliance maintenance policies. So you may want to check that out for the owner. Okay, moving on, going down to utilities. Please read this, take the time sometime. If you haven't read this whole lease, please take the time to read it, because I'm skipping over some areas and I'm going to the areas where we have to actually write stuff in. Tenants shall pay all charges for hookup and connection and deposit for providing utilities. And again, here's the key word. Everybody always misses this. It says except. So tenant is responsible for their internet, usually, unless it's included. They're responsible for Wi-Fi, usually, unless it's included in some of the higher end properties. But generally, the owner in his maintenance, for his monthly maintenance for the association, usually pays the water, sewer, and trash removal. In a house, the water, like I said, if there's a washer dryer, that may be individual and they may have to pay that themselves. So you need to make sure, again, with the owner of the property and the property management, what the tenant is responsible for. If you have people that are service members, please, or if you deal with people that are in the armed forces, please read this information because they have specific rights, and they're very lenient rights for people that are in our service. Landlord access to the premises. This is always very sticky. The landlord has access to the premises at any time to preserve the premises, a fire, a flood, anything that might happen that causes an emergency situation, that landlord can enter that property. The police can enter it at any given time that they get a call and they suspect something going on. So make sure your tenants are aware of that, especially nowadays. If there's anything that's maintenance or something to be done, usually a tenant contacts the owner or the owner's landlord or agent, and they allow reasonable notice. Reasonable notice is usually 24 hours in my book, could be 24 hours to 48 hours, but basically 24 hours notice is pretty good. So if they're going to be in there and they need to service the AC, if the owner has the AC done every year, just regular maintenance, they might just say, hey, the guy's going to contact you and he will give you 24-hour notice to come in. They can't just knock on your apartment at 7 a.m. and, let somebody in without your knowledge unless it's an emergency. So it's respect between the tenant and the owner to work this out basically, but generally 24 hours notice is enough. So they can't come in, obviously, just like we said, with tenant's consent. In case of emergency, they can enter. If a tenant says that they can't come in and they won't let the person in, if they give notice, they generally can enter that apartment. So just be aware of that. The tenants cannot unreasonably withhold consent for a person to enter. Sometimes the owners just get a complaint from neighbors. They might get a complaint about a pet when they're not supposed to have a pet. They may get a complaint about a leak from the association for any reason, but generally the tenant cannot withhold consent to let an owner in. The rest of this, I consider the rights. So I just would like for everybody to look over this for time. I'm not going to go over all of this information. And again, I'm not going to go over the 5 pages of the tenant rights, but please review this information about when a landlord and tenant can go in and give approval to go into an apartment. Renewal extension, we talked about that. It can be renewed or extended only by a written, signed by all parties, the landlord and the tenant. An agent and a tenant renewing a lease is not a legal lease. The owner has to sign off on it. So Memo kind of touched on that moments ago. He said that, but the agent said they have a renewal of a lease. Unless that landlord has agreed to the renewal and it's written and it's 1 year, that's the only way an agent can be involved in it. So be aware of that. Lead-based paint. Lead-based paint is units before 1978. And this is the portion, if it's built, if the building, and again, if you don't know when a building is built, look at the tax roll. Again, you go to the tax roll by going to the listing, tapping on the tax ID number, or it's also called the property ID number, the PID. Sometimes they refer to it as that. So property identification number. So just tap on that, go to the tax roll, and it'll show you when the building was built. So anything built prior to 1978, they have to fill this out. The lessor is the owner. So it's here. So they have to tell if they know. Most people don't know. So generally, I check that the lessor is the owner, landlord, has no knowledge of lead-based paint and they have to initial right here beside the B. Okay, so that's that part. If it's A, it's here. If it's B, if they know that there's lead in it, which I've never had anybody ever say that there's lead in a property. But however, just make sure that it says known, any known. So anyway, we do here, the landlord owner initials here. On your behalf, the leasee is the tenant, okay? And I don't know why they don't use tenant or leasee consistently, but it goes back and forth. So again, I put here lessor, which is the landlord, has no reports of lead paint in the housing. And on Form Simplicity, there is the Protect Your Family from Lead in Your Home. You should know where this is. You can email it to the tenants if it's a property. Only email it to them if it's a property built before 1978. Otherwise, you don't have to email it. So it is on, it's on londonfoster.net under our contracts there, and it's under our information for you. And it's also on Form Simplicity. So it's called Protect Your Family from Lead in Your Home. But if they've received it, they initial here, they don't put a check mark, it's initials. And if there's more than one person, they initial it, and they initial here if they have received it. Okay, the agent's acknowledgement is here, that you've informed them that there may or may not be lead in the property. And that's what this part is for. This is the legal part from the state of Florida, that we have to give this to every client if it's built before 1978. Okay. Again, the lessor, the signature here is the landlord. If there's two agents of his landlord, you put that here. Leasee has to be signed and dated. Agent signature for the tenant, agent signature for the listing agent. Okay, they have to do this. Attorney's fees, if you have a lawyer. This just goes over all that. Again, I'm not going to go over this part. Time is of the essence for the leases, and you make sure that everything is signed and as quickly as possible for all parties. We're in a very competitive environment, as we've said before. So time is of the essence, especially now. If you see a property and your client wants it, have them to make sure all their documents are in order. Do it quickly, do it right away. I suggest offering, not trying to go down too much on the lease, because they may not do it and you may not get the property that you want. So do your comps, so what's going on in that building, and make your offer appropriately. So this just tells you about the time, and it goes over landlord and tenant in good faith. So you just want to make sure that you're doing everything in a timely manner and very professionally. Tenant's personal property. This is very important right here. This goes back to what I was talking about getting the insurance. So this has to go with that. This is section 25. Tenant's personal property. Tenant must initial this box for the following provision. By signing the rental agreement, tenant agrees that upon surrender or abandonment of the recovery of possession due to death, the last remaining tenant shall not be liable or responsible for the storage or disposition. If a person moves out, they have to take their stuff basically, and that they're responsible for it. That the landlord is not responsible for their stuff. If they stop paying their rent, or for any reason that they're not there any longer, the landlord is not responsible for storing this personal property. So they all sign off on that. We had a lot of properties during COVID that people either left town, property was abandoned. If the property is deemed abandoned, the landlord has the right, after properly notifying the last known address. Again, that's why our address on the driver's license is important. If they notify them that the property has been basically abandoned, there's a whole section in the Tenant Rights about abandoned property. You may want to look over that. But that's what this refers to. If it's abandoned property, the owner's not responsible, the landlord's not responsible. Of course, your name goes here. Tenants have to sign off. It's initialed. My favorite page is this page. If somebody tries to break a lease in the state of Florida, the owner has the right to keep up to 2 months of rent, 2 months of agreed upon rent. In my case, my monthly rent was $3,000. So this owner has, if this is checked and if the tenants agree to this, they have the right to keep up to 2 months rent. So for liquidated damage or early termination fee. So if they check, the tenant checks, I do not agree with this, that means they can litigate, that the owner has the right to litigate and seek damages. They would have to go to small claims court basically, or obviously get an attorney to try to come after the tenant for not paying. If the tenant wants to break a lease, if they intend to break the lease, or if they do break the lease and they sign this, it's really the easy way out if it's just 2 months. If the tenant has 10 months left on his lease, the owner can actually come after that 10 months right here if this box is checked. So I generally have my tenants agree to this because I think the least amount of money that they would have to pay would be the 2 months rent and not what the owner could go after damages. If it's a furnished apartment and there's damages to it, he can collect both the damages to it and unpaid rent. And he can also keep the deposit because, and this doesn't mean just the deposit, this is liquid damages in addition to that deposit. So if this tenant, in my example, broke their lease, the owner has the right to go after $6,000 for the liquidated damages plus the deposit because of $6,000. So this owner could basically take $12,000 from the tenant in this situation because they've agreed that they already put up $6,000. And the minute that a tenant breaks the lease, the owner is allowed to keep that security deposit for a broken lease plus the $6,000. So this is important page. Make sure everybody signs it and that the box is checked. Some people sign it. I'll see leases and this has been signed by the landlord and the tenant, but the box isn't checked. And there's no option here if it's not checked. So then we would still have to litigate or fight over these amounts of money. And I would say if it's a long lease and if there's 10 months, 9 months left on it, the owner's probably going to go after him for the full amount of his 9 or 10 months, whatever is left, plus his deposit, keep the deposit. So be very careful about this page. Okay, the rest of the lease is the landlord tenant acts, and this breaks down the sections of the Florida code where it's found and the code that applies to the Florida code. So I suggest that all of you read this, and I included it here on this presentation, which we didn't on our previous year's presentation, because sometimes people don't think that this goes into the lease or that they have to put it in here. Notice that the tenant and landlord have initials. So these pages 8 through 18 have to be initialed by the landlords and tenants and have to be part of your lease. Our leases have to be page by page, single pages. When you give a lease to a client, it cannot be back and front. It has to be all full pages. And that's to verify that nobody misses a page, that it wasn't overlooked for some reason. So it has to be page by page, either emailed or printed, however you do your leases. It has to be signed and it has to be page by page, no double-sided leases or contracts to lease. So keep that in mind. There's a lot of legal information here, a lot of information about what to do if the tenant's maintaining the apartment, what to do if they want to break their lease, what rights they have as far as leaving the lease, about renewing their lease. So all of those things are broken down in here. It also gives you information if the tenant wants to complain about the owner or wants to redo something, that's in here. Termination on either party is here. Vacating, remedies for vacating, right of possession. So there's a lot of information here in the state of Florida, and this is all part of the lease and all needs to be each page initialed by all parties. So this lease was actually originally adopted and they haven't updated it, I think, since 2016, but it's still in effect. And this is the most current one that we have, just so you know. London Foster always keeps the most current leases and contracts at least up to date. So we've got your back there. And also on Form Simplicity, they also keep the most up-to-date contracts there generally. So make sure you're always using the most updated contract. So that concludes the lease and the contract to lease. I'm sorry we've gone on for 2 hours, but hopefully you've gained some information and some pearls. And again, my examples are just examples that I've used. If you have any questions or anything, you can ask now on our chat, or you can hit me back at my email, which is nanette.realestate@gmail.com. It's nanette.realestate@gmail.com. You can call me at my telephone number or text me at 305-588-9381. If you have any specific instances or any questions or any issues, I'll be happy to go over it with you on an individual basis or on an individual property. Remember, the lease that we did today is for a condo, and it's not for a single family home. It's not for a duplex. So again, those other contracts are on our website at londonfoster.net. I hope you guys have learned some things today, and I'm here if you need me. Memo? Anybody? So thanks everybody for attending, and I guess we'll wrap it up right now. So have a great day and let me know if you have any questions. I'll check the Telegram to see.
Hey, Nanette,
Yes.
did he finish?
Yes, we're all finished.
Oh, okay, okay.
And I asked for
Sorry
questions.
about that.
No, I just asked for questions. So we're all finished. Everything is, we went over. I told them to contact me at my phone number.
Yeah, I'm walking around, so I got disconnected. Pero,
Oh, no problem. So we're
Nanette,
all
thank you
finished.
so much, and looking forward to the next one.
Okay, thanks everybody. Have a
Okay,
great
my
day.
friend. Take care,
Thank you.
everybody. Have a great day. Bye-bye.
Bye.